Well, thank you, Fred. I'm really quite delighted to be back here at the Institute. So you can hear me now. This magic, this microphone came right on. Before I start, I really do want to thank a few people, of course, starting with Fred and the Institute, for inviting me to write this book. You know, this is an unusual book for the Peterson Institute to take on, because it is comprehensive. It tries to deal with a lot of international issues at the same time in more or less detail, as you'll see if you go through the book. It doesn't really take on a very specific kind of international policy question, hints at quite a few of them. So I'm very pleased that once again you're willing to let me bring this book out with the Institute here. I'd like to thank as well the advisory group here at the Institute that gave me some advice all the way along this process, and let me apologize to Fred and everyone else for how long it took. It did take quite a long time to get this process finished, but again, I'm very happy to be standing up here today. And I thank all of you for coming as well. So let me begin by saying, why do this book now? Fred already hinted at it, but let me just tell you, I have increasingly over the years been getting more and more inquiries about updating the 2000 book. Obviously things have changed quite a bit, so there are a lot of new things to write about, particularly in the global IP area. You know, in 2000 we had the recently formed TRIPS agreement at the WTO. Developing countries were only beginning at that time to think about how they would organize their intellectual property regimes. There was a lot of ferment going on then, even among the wealthy developed countries, which is still true. But a great many new issues have arisen. Excuse me. Of course, there's both increasing domestic and international interest in intellectual property rights. It isn't just public policy questions. It isn't just you know, big fights among electronics firms in terms of commercial activity, but also people are generating very personal connections with intellectual property, unlike ever before. I have a box in chapter 1, if you look at it, on the new ownership society, what I call the true new ownership society, in which governments around the world are working hard to make sure that we can own things we come up with. Sometimes you wonder about exactly the wisdom of some of those decisions, but there it is. You know, if you own a home, that makes sense. Maybe you should be able to own any kind of intellectual creation you come up with as well. So I think these personal connections have become very important. And of course, all of the time in the news we read about intellectual property. You can't go to the store without encountering it. So it's become a much more personal and widespread issue than it was before. A number of these global policies continue to evolve. We have some unresolved questions that need hard analysis. And of course, finally, intellectual property rights remain as controversial as ever, and probably more so now as developing countries are engaging much more fully with this issue, and technologies continue to change more rapidly than legal reforms can keep up with them. So why this book now? Because I think maybe it's time once again to try to bring some accessible economics to the table. You know, it's really true that there's been quite a bit of recent economic and legal scholarship, some of it done by people in this room, that is very useful and really should be brought to wider attention, whether that's in terms of what individuals read or policymakers or legal scholars. So what am I trying to achieve here? Well, really one, and I emphasize one, economist stock taking. Where are we? What do we think we know? And I use the word know advisedly in this area. And what's missing? To try to document and assess the major changes in global intellectual property policy since the onset of TRIPS. TRIPS was by no means the end of history as far as intellectual property is concerned. To call current controversies into greater attention, to provide a discussion of new economic evidence on the role of intellectual property rights in innovation, in technology transfer, information markets. I don't know if you read the volume from 2000. If you did, you saw a long chapter about that, but those studies that were reviewed in that chapter were fairly primitive in what they were able to say, and I think we have much better evidence now on these very important questions. To do what I can to provide some economic analysis of questions regarding the structure of IP markets, this is the kind of thing that didn't appear in the earlier volume, and that's why this one is considerably longer, but including some obscure to the public, but nevertheless extremely interesting and important questions, such as the exhaustion of intellectual property rights and arbitrage through parallel trade, geographical indications, which in the book I refer to as geography made delicious, digital licensing, which is everybody's big issue these days, along with pharmaceuticals, of course, and some commentary on enforcement issues. And to try to comment to the best I can on the economics of how intellectual property rights interact with the provision of public or quasi-public goods. This was virtually untouched in the 2000 volume, and there's a lengthy treatment of these questions in Chapter 5 of the new volume. I hope that I'm able to shed some light as an economist on these very complicated questions. And finally, to offer some policy suggestions where I think they're warranted. As we go through this presentation of the volume, I'll mention 4 ideas that are actually in the first chapter of the book. I do want to say that many of you will wonder about the wisdom of these ideas. You might find them poorly thought out, perhaps, or naive. I hope not. That's not the case. I've tried to think as carefully as possible through them, but I did want to raise them in this book to sort of put more of these questions on the debate table. These proposals I put forward for you, or these ideas, they're really not so much proposals, based on economic evidence to the extent that I can put it together, economic logic, theory, sometimes just on common sense. So we'll just see what people think as they read through them. Throughout the book, though, there are a lot more policy issues that I raise and I hope provide a fairly thoughtful treatment of that I'll spend a little bit less time on. So since I don't really know exactly how to go through a very complicated and comprehensive volume like this, what I think I'll just do is overview the chapters, but spend a little bit more time on some of the deeper issues and just make a passing claim about some of the others. But, Chapter 1 is designed to try to set the stage here about the ever-increasing importance of knowledge and creativity as a basis for economic and social progress. Every country in the world writes all the time in their government policy statements, in the commercial sector, in academia, about the knowledge economy and the need to plug into the knowledge economy and how best should you actually put your economy in place to really take advantage of knowledge and changing processes. As I mentioned already, the fact that intellectual property rights have become absolutely ubiquitous, the new ownership societies I was talking about. I don't know if you know this, but among economists now, at least microeconomic theorists, there's a patent race going on. Everybody's writing new auction models, in their theoretical papers, and then patenting the auction models before they publish the papers in the journals. And so, if you look at the websites of major microeconomic theorists, you'll find that many of them list their patents before they list their publications and their education, and that's really quite interesting, I think. And as you might imagine, also at my own university, our technology transfer office is often calling up the economists and saying, "Why aren't you doing this too?" All right, so new forms of innovation and creativity. I spent a lot of time in the book about network innovation and sort of creativity that involves mixing and mashing up digital content and trying to come up with new ideas, ways of thinking about things. Are they consistent with traditional standards of intellectual property? There's a norm out there in the world. If you build it, they will copy, right? If you come up with a new intellectual creation and you put it into the marketplace and there is a rent to doing that, then somebody's going to copy it. So what exactly should be done in terms of enforcement? And of course, we're always striving for a new balance on the global scale. So that's to try to set the stage. The second chapter, which I call the big global upgrade, really is about showing that there's been a remarkable expansion since the TRIPS agreement of legislated patent rights around the world. Not just legislated patent rights, but also how well they're enforced. There's also generally stronger protection of copyrights, trademarks, plant variety rights, and trade secrets as well. Let me just show you some data if I can here, and I'm going to tell you that these data, I have to go through several points here first, come from Walter Park, who's sitting here at his table back there. Walter is, at least in our obscure area of economics, international economics, the most public-minded person there is in the business, because he puts together these indexes of patent rights every 5 years for all countries in the world, and we all use them to analyze what seems to happen as a result of patent reforms. And just to put this in terms we all understand, if Walter had decided to patent those data, I think we would have had to have a competition authority declare them to be a standard essential patent so that we could all use them under some sort of compulsory license and do the research we need to do. So thank you, Walter. But anyway, if you look at these data, I don't want to spend really any time on them, but if you just to see what they're telling you, this index ranges from 0 to 5 in principle. And just look at China, in the second panel there, or India. Both of them increased their legislative patent rights by over 200%, almost 300% in the case of India since 1990. So these are large changes. You can ask Walter how these things are actually calculated, but they are, take my word for it, very large changes. And what's also interesting in the top panel is that the really big changes among groups of economies have come among the middle income, lower and middle income and upper middle income economies. And those are precisely those countries that the technology developers and the creators in the developed world would like to see their rights strengthened, because they're the places where there are a lot of consumers and, of course, a lot of competition from local imitators. Another way to see the same thing is in 1990, you had, the developed world in yellow was pretty strongly protected, but nobody else was. By 2005, you have this linear relationship. The lower the income, the lower is the protection for intellectual property, but nevertheless, much higher, and it just follows income in a pretty much lockstep linear fashion. So there's been a big change. Also in the book, I try to document these changes using some other measures. It's of interest to point out in passing that if you take, like, the World Competitiveness Report measures of intellectual property protection, you'll find that in the developing world there's been more improvement or strengthening of intellectual property rights than there's been trade liberalization, which I think is quite, these things are in some degree apples and oranges, but nevertheless I think that's an interesting observation made by them. So where do these changes come from? I think you're all familiar with TRIPS, with the TRIPS Plus arrangements and free trade agreements. But of course, many of these emerging economies, China, Brazil, are very good examples, Mexico, emerging domestic interest in stronger IP protection as well. So the big question in this chapter is, how well are these changes working in economic terms? And I'll have to leave it to you to read as you wish. There does seem to be some positive evidence from econometric studies of positive domestic innovation impacts, about 10 or 12 studies of this so far. Suggesting that research and development spending goes up in countries that reform their intellectual property rights, at least among the middle-income economies. Interestingly, in terms of patents, there's more non-resident patents that get taken out than resident patents, so that should tell you something about the politics of this. There's very clear evidence of additional market-based technology transfer to middle-income and emerging economies. Some 17 to 20 studies of this so far now in the literature since 2000. And the consensus, and pretty overwhelmingly, is that what these changes in the system are doing is behind the scenes, sort of improving the plumbing of how technology is traded across borders. And so that in fact you get more efficient information markets and more technology transfer through market-based media such as licensing and foreign direct investment. And some evidence of positive spillovers into productivity gain and more economic activity in local economies. That's a little bit less clear in the research, but I think you can make that claim. So as I said, the bottom line, these changes are improving the plumbing of global technology markets. There's really not much evidence of any of this happening in the poorest countries, which is unfortunate. but I think you can imagine, the reasons for why that might be. But in any case, if you think that one of the important reasons for having a global shift in the regime of intellectual property protection towards stronger patents is to improve technology markets, to increase technology diffusion, that seems to be happening, at least for those countries that are plugged into the system. So that's basically what Chapter 2 is about. I hope you'll find that interesting. Chapter 3 is basically a description of the global governance evolution since the time of TRIPS. I don't think I'll spend much time on that at all this afternoon, because a lot of this is going to be well known to you, except perhaps in some of the details. I do go through IP dispute resolution as an economist, and I want to warn you, especially the legal scholars out there, if you read my descriptions of the 7 or 8 cases that I describe on dispute resolution at the WTO under TRIPS, that's just one economist reading as well as he can what these things actually say. I'm sure that the legal analysis is a little bit weak in there, but nevertheless, each of those cases makes an important point about sort of policy space under intellectual property rights. There is a long discussion in the book about TRIPS Plus issues, not much on the Trans-Pacific Partnership, but again, that's an example of an attempt by the United States to export very strong protection. And a long discussion of WIPO in this context. And I do want to tell you that my take on this kind of issue is that WIPO is an important institution. It's an institution that has been sort of in the backwater of global governance for a very, very long time and wasn't doing much at all other than just registering some treaties and conventions. But it has come under tremendous pressure to actually become a development organization through the intellectual property system. That's a big change in the world, very big change in the world. And I know it's not at all, I don't want to triple negative you there, it is highly controversial as far as some of the developed countries are concerned. So I think there's a long discussion in the book that I hope you find interesting in this concept. But of course, to the extent that the development agenda can be characterized as a pushback against stronger IP regimes in the world, there's the counteracting pushback, which is on enforcement. So many of the wealthier economies in the world have negotiated the Anti-Counterfeiting Trade Agreement, the ACTA, which I think they hope to become a new global norm in enforcement. It is much more rigorous in its provisions than the TRIPS agreement is, for example. Perhaps overly rigorous, because it doesn't appear that there's much likelihood that it will be enacted into law in enough countries within a soon enough time period to actually take effect. But nevertheless, if you read what happens in ACTA, and there's a long description of it in the book, this is a very strong change in enforcement emphasis away from sort of do your own thing in TRIPS to here are some very prescriptive things that countries should be doing in terms of especially digital licensing. So the whole point here in Chapter 3 is to show you, or is to discuss the fact that there is this ongoing churn and evolution about intellectual property protection. So the policy system is still evolving. So the next, and really the next 2 chapters are the substantive meat of the book, so I hope you'll get a chance to read them carefully. In Chapter 4 in particular, try very hard to bring in a lot of economics to areas that people generally don't think about as economic issues. But the unifying theme here is that we have this global system, and it comes under a lot of pressure, a lot of stress for a number of reasons. Chapter 4 is about systemic pressures that arise from, in quotes, private use of intellectual property rights on an international scale. I mean, we all know this, but intellectual property rights are defined as national rights, not international rights. So there will always be some tension to the extent that global policies are not harmonized. And of course, that would raise to an economist the interesting question of at what level should you harmonize them, if at all. The book discusses those issues in considerable length. But here in Chapter 4, I'm interested in bringing out a number of Very interesting questions that are widely discussed among those who are in the business, but not at all discussed among those who are out of the business. And one of them is the simple fact, many of you know all about this, Bruce, you've been writing about this for some years now, massive patent application burdens at the patent and trademark offices of the world. But more than that, a lack of transparency in who actually owns patents, and ultimately a need for greater cooperation among the intellectual property offices of the major economies, including places like China. These massive applications increases come from lots of reasons. One simple one, it turns out, is that the world has come to the view that a patent application is necessarily an increase in innovation, and so more patent applications in your data suggest that the economy is becoming more innovative. And so in China, in fact, they're now paying people to take out patent applications, and the quality of the patents that are registered are questionable, to say the least. But China is increasing its patent numbers very quickly under that kind of a framework. So what kind of cooperation could you imagine? Well, to begin with, you could see the patent and trademark offices doing things like specializing in their prior art exams, with those specializations being along, essentially comparative advantage lines. The Americans are very good at, because we get a lot of applications in pharmaceuticals and biotechnology. The Asian offices are somewhat inundated by electronics patents. So you can imagine something like that emerging. And then either mutual recognition of the patents themselves, which is unlikely, or at least recognition of the prior art searches across these patent offices. And it's quite interesting. The United States, of course, the USPTO has these patent highways in place with several of their sister organizations, if that's the right phrase. I'm not sure it is. They're corresponding organizations, under which they actually do take prior art searches from these other patent offices and use them to expedite their own applications, and have cut the pendency period for certain industries from something like 2 years to about 3 months. It's an amazing thing. So there are great efficiencies that can be available through this kind of cooperation. But I would argue more than that. This is sort of idea one in chapter 1. It would be really beneficial for global innovation and technology diffusion if we were to figure out a way to establish easily searchable databases of industrial property, either at the major patent offices or at the WIPO itself. I'll talk about how that might happen in the text in the book, excuse me. But if any of you have ever done a patent search, I think you have some idea about how difficult that is, how hard it is to know exactly what's protected and what isn't. Not all patent applications, in fact, are easily available. And there are a number of benefits that one could get in terms of landscaping patents in particular industries if this kind of a database were available. And I would say not only in patents, but in all forms of industrial property, to the extent that an investment of that kind could be made. So that's one area of this chapter that I think is worth thinking about. A second, which I'm not going to talk about much at all, is on the use and misuse of patents in setting standards. Actually, Fred mentioned in his introduction that I am directing a study at the National Academy. We're having a conference next week at the National Academy, if anybody wants to come for that, on the question of global, or how international different jurisdictions around the world actually manage patent ownership questions in standard setting organizations. Very interesting question. This book actually points out that there's a lot of different strategies that countries undertake, including China. Long discussion of China in this context. But I think we can leave questions about that till later if you like. I've written quite a lot about the exhaustion of intellectual property rights and arbitrage or parallel trade across countries to take advantage of exhaustion. I'll just say a few things about it. This is complex economics. I'll try to describe it as best I can, but it's not as obvious as you might think. Parallel trade, where there's one high price here and a low price there, those prices are not necessarily bad by themselves, those price differences, right? Intellectual property developers want to be able to differentiate their prices. But if you allow arbitrage between those things, the fact that those prices may come together is a good thing where the prices come down, not necessarily a good thing where the prices go up. That's the easy economics. The harder economics shows that, in fact, that may not happen. Prices might go apart. as a result of parallel trade. In fact, and you can get models that show things like R&D could actually be diminished as a result of parallel trade. So it's not such an obvious thing. And I go through all of that to the extent I can. I do have in the book a comment on what I guess is now an old issue, but it probably will come up again in the context of healthcare debate, whether the United States should relax its restrictions on imports of patented brand name drugs from Canada, and possibly wider than Canada. And I'll just sort of tell you, I'm cautious about that, but if I argue that if in fact that's going to happen, there's a sort of coordinated, phased way that you could do that could be beneficial for both Canada and the United States. The Canadians are not excited about the prospect at all, since they think that that would drive up their prices or reduce availability on their market. But there are ways to deal with that. And I also, in the book, talk about the free riding problem in R&D in pharmaceuticals that I think can be resolved fairly easily under this kind of an arrangement. Next subject in the book, and I'm not going to say much about this one either, the economics of geographical indications. As I said, that part of the book is called Geography Made Easy. Sorry, Geography Made Delicious, not easy. Those of you who follow this know what the European Union wants. This is their sine qua non, if I'm saying that right, in the IP area. They want the world to protect geographical indications very strongly. The way how they see that as a priority is an agricultural policy issue. They know that they need to start scaling back on their, well, many people in Europe realize that they need to scale back on their agricultural subsidies, and what they want to do is to substitute for that increases in value added in the farm for farmers and through artisanal producers of cheeses and wines and the rest of it, so that in fact income can be generated that way rather than through subsidies. That's what they're trying to do. It's not an easy thing to achieve. I do discuss in the book the question of whether there's scope for using geographical indications to foster rural development in poor countries, and my answer is could be. It could very well be, but have to think about that quite carefully. So, coming to the end of this chapter 4 here, there's a long section in the book on digital goods and licensing problems, and I will just tell you, although I'm trying to look at these questions the way an international economist might, I find this to be that area of intellectual property where coming up with workable solutions, workable policies is probably the toughest, just because of the technology and the technological change and the ease with which things can be defeated. So there's a bit on the economics of downloading and file sharing. It was quite an interesting thing about the sociology of economists. When this first became an issue for the music companies about 10 years ago, there was this debate among economists about whether, in fact, downloading was killing the digital industry, compact discs basically. And several papers that were published at very high levels suggested no, that in fact this was all just regular competition and everything was going to be good. I think that debate is now over. So now we've moved forward to how to actually enforce copyrights in digital goods on a global scale. And I think that's really, really tough. There are limits to the kind of licensing solutions that exist now. What I argue in the book is that perhaps we need to move further toward a system that features something like a neutral framework that supports innovation in licensing models. I'm not going to stand up here and tell anybody in that industry how to develop new business models. I'm nowhere near smart enough to do that. But I think we could develop a better sort of global policy framework for managing and encouraging global licensing as opposed to more specific regional kind of licensing. A system that makes paying for content as easy it is to download the content. That's part of the problem in much of the world, that it just isn't that easy to work with your own ISPs and your own collection societies to find licenses to download music and movies. And recognizes that digital licensing should have global reach. So idea 2 in this first chapter, and spelled out at some length in chapter 4, is to actually have some discussion at WIPO that would recognize that copyright owners have a global digital transmission right. I think many would argue that they do already, but if you look at, in fact, the balkanization of global law in this case, I'm not sure that's true. And then encourage competition in national and international collection societies. That sounds easy, but that's actually a pretty big radical suggestion that, you know, every country has its own music collection societies, digital content collection societies. All of them have their own rules and procedures, so it's a pretty fragmented, inefficient kind of way to sell your stuff internationally. And so I think actually globing, you know, having basically free trade in competition services or in collection services would actually be a beneficial thing for everybody concerned, except the ones who run those existing collection societies. A little bit on enforcement economics in the book, actually a lot in the book. I argue in the book that there is a good reason for the world to devote more resources, more time, more effort to enforcing intellectual property rights better than we do, or especially in the developing world. There are, to me at least, large economic and social gains to effective enforcement. Part of it is because medicines and food products can be tainted or ineffective, and you can extend that problem through all kinds of products where, you know, automobile parts and aircraft engines, if they're not in fact legitimately produced, there's a question about the safety of these goods. But there are even additional gains in terms of innovation and creativity that could be generated in the developing world through better enforcement. But there are obvious political economic problems here of the imbalance between the costs and benefits a lot of elements of that, but to a first approximation, the short-term winners from stronger intellectual property enforcement in developing and emerging economies will be the owners of intellectual property, who tend largely to come from the developed world. And so you might ask these governments in the developing countries, do they really want to invest a lot of their development resources in that kind of enforcement? And they'll tell you no. And the one important sort of TRIPS case here in dispute resolution is the US-China case. Again, I probably mischaracterized the law of that in the book, but what it basically says about China's enforcement inadequacies was that, as inadequate as they might be, that's not inconsistent with what the TRIPS agreement requires. So it does require something more than just working through the TRIPS system here. So I've never gotten very far with this idea, but I always put it out there. Idea 3 here would be to in fact put a small levy on applications for industrial property, patents, geographical indications, and so on, including their renewals, and possibly copyrighted content to the extent you can figure out how to do that. There are some ideas for that in the book. To fund better enforcement measures, to actually, you know, take some of the burden from the beneficiaries, and then use them to improve the international system of enforcement. All kinds of safeguards would have to be added to that kind of a framework, but I think in fact there's some sense in doing that. Even at WIPO, they're beginning to think about whether that is sensible. Okay, so I'm taking too long. Let me just tell you that the final substantive chapter here is on intellectual property rights and global policy challenges, sometimes called public goods, where additional issues arise from the interplay between IP and the provision of these public and quasi-public goods. These are, again, deep and complex questions. Economics can offer something to say about them, although even within economics profession, there's nothing like a consensus about the best policies to undertake in these areas. So what you have in this book is one person's view here. We basically ask two simple questions here as economists. Does the global IP system raise enough roadblocks to innovation and to diffusion of knowledge to justify changes in the way things are organized, norms and processes? And my answer to that is it depends on the area you're talking about, as I'll mention here just in a few minutes. Second, is reliance on private exclusive rights enough to meet needs for innovation and diffusion of new technologies? And again, extremely complicated question, but my basic answer on that is for purposes of diffusion, maybe. Certainly in the case of climate change technologies, that seems to work pretty well. For cases of innovating, incentivizing new R&D, developing new drugs, new sort of green technologies that would be specifically organized for developing country markets, I think probably not. And so additional resources need to be brought to bear in those areas. Okay, so these are the issues that are actually treated in this chapter 5. Something on IPR's policy space and economic development. I'm not going to say much about that. But if you're interested in, what's been happening, for example, in compulsory licensing in developing countries, what's been happening in terms of competition policy in China and India and Brazil, by all means, take a look at the book. There's a discussion of those things, but I'm going to move on to some other areas. Problems and progress in public health, essentially the access to medicines question. Mostly the discussion in the book here is a progress report on what's been happening so far. This, of course, was the original issue, public goods issue, with respect to intellectual property in the wake of the TRIPS agreement. And I'm sure you know all about the paragraph 6 waiver and many of these other issues that came up to try to expand access within the WTO system, not very effectively. But I think the operation of foundations, public-private partnerships, sort of connections between universities in the developed world and the developing world have all sort of come together to actually improve the system considerably. So the problem with AIDS, access to AIDS drugs, is much less difficult than it used to be. We still have very significant problems in incentivizing innovation in new medicines to treat really sort of low incidence but deadly diseases in the poor world. But even that's changing through sort of targeted grant programs and the foundation. So I think things have done well there. But there are still some important changes that could be made in terms of actual access and licensing models. Intellectual property rights, in my view, there have not been the problem everybody thought they would be early on. In some cases, you can see prices going up. In some cases, you can see access limited. But in most cases, I think the operation of especially patents and trade secrets have actually done good things to work out what the obligations and rights are of these public-private partnerships in terms of getting more innovation on the market and into developing countries. So I think the scorecard there is reasonably positive. I have a section on technology transfer and climate change, something I've been writing about lately for the OECD and other places. I'll just tell you briefly. A review of the evidence there suggests there's not much evidence of a problem yet that patents are restricting diffusion of technology in the developing world. That may not be true going forward as we get more and more into biofuels, biotechnological solutions, but so far there's not a lot to be concerned about the IP system. And so what that's really about to me is finding incentives to actually diffuse and adapt technologies into the developing world in a better way than we've been doing so far. Some ideas in the book about that. And again, there's a section on agriculture and genetic resources. I want to say a few words about this because this is where an economist can actually offer some interesting perspective. This is really what we would call a vertical R&D problem, and so is the next one I'll talk about briefly, knowledge. So you have vertical R&D. This is a case where the stock of genetic resources out there really is the commons from which we need to develop new biotechnologies and new pharmaceutical treatments and new medicines and on. These are extremely important issues and sort of new seed varieties for agriculture. How does that innovation system work? Well, you have this baseline floor of a commons area. Then you want to figure out where to put the intellectual property in order to incentivize the actual applications. Do you put the intellectual property in at the basic level so that wherever the commons is, somebody can own that? Or do you actually favor a system where the patents and other forms of IP would be on the applications? Well, I think putting it that way, most economists would argue the second approach is probably the more beneficial one. That's not what we've been seeing, though, in the world, particularly in the developed world when it comes to sort of university innovation and so on. So there is that big question about where to license the IP. And I'll give my answers in the book. There are, in principle, enormous gains from trade that have not been unlocked in this area. What sometimes is called the grand bargain, trying to figure out a way to take this amazing stock of genetic resources and convert it into income for those who live and own those genetic resources in the context of developing innovation in the major economic countries. And I think we're sort of really lagging there. So talk about access and benefit sharing, generally appropriate. I will tell you, if you're interested, A number of developing countries, such as China, Brazil, India, are putting into their laws requirements that if you're going to get a patent on something that's developed from genetic resources, if you want to take out a patent in those countries on something developed from genetic resources, you must disclose the origin of those genetic resources. They'd like that to be a global standard. Having thought through that at some length, I think that's probably a mistake, and so in the book I sort of argue against that disclosure requirement. Okay, almost done here. There is something on traditional knowledge, very interesting, but economics has very little to say about that, so I think I'll just let that go, other than to tell you I actually think the system of IP as it exists now can be used to try to improve returns to traditional knowledge. The last major area is on basic knowledge and science as an international public good. Again, this vertical R&D problem I mentioned a moment ago comes into play here, but now we have a much more complicated innovation structure, where in fact we have a system where the innovation networks exist globally between universities, across borders, among firms, between those who would license knowledge and turn it into applications. And these are, they go through the supply chains, very complicated economics, very different from the standard conception of a patent, in which you develop something like a sewing machine, you get a patent on it, somebody else comes along, develops another sewing machine, maybe he gets a patent on it, but that's all very linear. We're in a different world now in this kind of an area. So I'm not so sure the existing patent system is appropriately structured to try to convert the knowledge commons into the kinds of applications we really need, partly because of the large transactions costs that are emerging among universities, because of their ability to patent so really basic knowledge. The international dimensions are even more complicated here. There's a long discussion of that in the book, but basically the story here is, under a system where you rely on private property rights at all levels, whether that's at the basic commons level or on the scheme, you're unlikely to see enough investment taken by both countries and universities, national governments in countries and universities, in the development of basic science. And so I think this is a restriction we need to worry about. I'm talking in the book about the possibility of a global access treaty in very limited terms to basic science. I think it's probably a good idea, but extremely complex in how to get from here to there. So I talk about how you might get there in the book, but it's something I want to put out there for people at least to think about. And I think it could deal pretty well with some of the free riding issues that are often considered to be a real problem in this area. Last sort of general comment here before I wrap up. If you sort of have been listening to me, you'll see that a primary common denominator regarding these public goods, and often earlier discussion items as well, is that what we're really about here is not just finding ways to encourage innovation, development of new products, but also making sure that they're transferred into places where they're most effectively used or most importantly needed. And, probably the biggest implicit debate out there between the developed world and the developing world is that there aren't enough mechanisms in the private system of intellectual property to encourage technology transfer and diffusion in some of these public goods areas. I think that's an extremely broad issue, could be debated for weeks, but in some areas I think that's a fairly accurate statement. So to me, a primary common denominator regarding these kinds of questions is finding mechanisms to increase technology transfer while also sustaining prior innovation incentives. That sounds good. But idea 4 in this first chapter that is discussed in chapter 5 is to see at least the G8, G20 countries, even broader than that, including China, maybe other countries that actually have enough reserves to afford contributions here, is to figure out a way to make a coordinated announcement that the technology transfer, development, and public needs is in fact a clear global priority, and then to try to figure out how to put some actual mechanisms into place to back that up. Okay, I will just sum up, last slide here, by raising some questions for you to think about. Is the current system of norms consistent with a world of cumulative innovation, network economics, global marketing, and digital creativity? Big question. I think in many ways it is up to the task, but needs some modification. Is it prepared to absorb the emergence of major economies such as the BRICS that have their own expectations about where they'll be in the innovation game? The system is under increasing pressure, and you know, just thinking about this at a very high level, seeks a new balance and sort of is getting there, but slowly and in fits and starts. I think the WTO TRIPS approach that we have can be built upon in many important ways, but it's not likely to deal effectively with public goods issues for lots of reasons, not least of which is you don't want to shoehorn all of environmental policy or all of labor standards policy or all of knowledge policy into a trade agreement. It takes more approaches than that. And then the importance of energizing WIPO, as I said earlier, as an information repository, a place where there's analytical support and location for refining and developing these kinds of forward-looking IPR norms that I hope I'm getting across. But whatever happens, the system does need to accommodate broader interest in ownership. Really, it's amazing how creative the world is, and maybe how more creative it could be if we had the right incentives and mechanisms in place. But anywhere you go in the world, you know, in the poorest countries in the world, there are people who are astonishingly creative. And it would be nice if we had a system that accommodated those broader interests in ownership, these new forms of creativity and innovation, and reasonable access to this information across borders. It isn't just, or even very much, that it's the companies that are preventing that access. It's that the sort of fragmentation of policy across borders, as liberalized as you think the trade system is still reasonably fragmented on the IP side. And we need to figure out ways to try to accommodate that problem. So I will stop there. I think I've gone too long. And Gary, you were going to come up?